This is a lecture for my professional responsibility class. We're going to be talking about Model Rule 1.11 or 1.11, which is about conflicts of interest for government lawyers. Conflicts of interest for government lawyers. I'm going to break this rule into two videos. In one, we're going to talk about the rules, and in the second, we're going to go through the comments to the rule. So let's take a look at the rule now. So again, this is near the end of the section of the model rules that are focused on conflicts of interest, starting from 1.7 basically through 1.12. And so we are almost at the end here. And we're talking about the conflicts that arise when lawyers move from government positions to the private sector, or from the private sector to being a government lawyer. And this could be a district attorney, working for a public defender's office, working for one of the federal regulatory agencies, or in the Department of Justice, U.S. Attorney's Office, doing enforcement specialized on like civil enforcement for one of the regulatory agencies. Rule 1.11a says, except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government, one, is subject to Rule 1.9c. That you may remember that's about using information to the disadvantage of someone. And two, shall not represent a client in connection with a matter in which the lawyer participated personally and substantially as a public officer or employee, unless the appropriate government agency gives its informed consent, confirmed in writing, to the representation. And so you can go from the public sector to the private sector. Many, many lawyers do. And we really have concerns here that are very similar to the concerns in Model Rule 1.9 for lawyers moving laterally between firms in the private sector, which is we don't want to see someone switch sides in the same case. So you are working on a case for the government, and then you go to the private sector and work for the private party. Or it could be a situation where the government is bringing in enforcement action like pollution cases, and then the neighbors are also bringing some sort of nuisance action or indemnification claim or something like that for the same pollution, basically. And we have concerns about using information. Let's proceed. B, if a lawyer is disqualified from representation under A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless, one, the disqualified lawyer is timely screened from any participation in the matter and has apportioned no part of the fee therefrom, and two, written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with the provisions of this rule. And so this is our imputation and screening rule. When you leave government service, by the way, this also could apply to working for the judicial branch, although we're going to talk about judicial clerks in the next rule. But you could be a lawyer who is working for any number of federal agencies, the Social Security Administration, the Office of Hearings and Appeals, or something like that. And if you have a conflict in a matter, we're going to impute that conflict to your whole firm, which means your whole firm is disqualified from representing the private party in the matter, unless they screen the lawyer, right? Which means, as you may remember, nobody talks to you. You don't get to talk to anyone else. You're not going to have access or get to review files related to the case. You don't get to share confidential information, and so forth. C, except as law may otherwise expressly permit, a lawyer having information that the lawyer knows is confidential government information about a person acquired when the lawyer was a public officer or employee may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. And so I'm going to give a personal example. My last job before I became a law professor, I became a professor in 2003. My last job before that was that I worked for the Attorney General's office in Connecticut. In their Environmental Enforcement Division. And so I was an Assistant Attorney General, and we basically were dealing with pollution cases and cleanup cases primarily. And so when you're working on that, when you're working on a case, you find out about the companies that are polluting, and you see their financial situation and their location and their other assets that they own, and so forth. And so you end up being privy to information just because of the investigation that's underway. Even when they're making a decision about bringing an enforcement action. Now imagine that you leave and you go to the private sector, and now someone is it's a disgruntled former employee. It's maybe even if it has nothing to do with your case, the pollution case that I worked on, let's say, but I know a lot of kind of backstory about this particular local businessman or businesswoman, and so I shouldn't be able to use that advantage, that information, to represent private parties who want to litigate, whether in commercial litigation or tort litigation or property disputes or something like that, against that party. In other words, it's not fair, and we have a concern because the government has access. When you work for the government, you have access to a lot of information, and also don't even get me started about the databases that you can access and things like that, that could be useful, and that the other party should have to, normally private parties should have to obtain through discovery. How are we defining confidential information? As used in this rule, the term confidential government information means information that has been obtained under government authority, and at the time the rule is applied, the government is prohibited by law from disclosing to the public, or has a legal privilege not to disclose, and which is not otherwise available to the public. So there's some types of information that when you're a government lawyer you get, but it's a matter of public record, right? So if you go to the town hall tax assessor's office, any lawyer can find out who is the owner of title for for purposes of paying property taxes for a particular parcel of land. That's a matter of public record. So we're talking about information that the government normally can't just release to the public about you, or that only the government would have. A firm with which that lawyer is associated may undertake or continue representation in the matter only if the disqualified lawyer is timely screened. And when we say timely, we mean right away and before that lawyer divulges confidential information that could hurt the party from any participation in the matter, and is a portion no part of the fee therefrom. Now you may remember from our last rule, 1.10, which is actually modeled on this rule, which came first, that you still get your salary. If you have a preset weekly or monthly salary that you get, or annual salary, you're going to get that. What we're talking about is sometimes a firm will get a windfall from a sudden payout of legal fees, income of legal fees, and may distribute that among the partners, let's say, or allocate it to the attorneys, but not you, right? If you are screened from the case, then you also shouldn't have a financial incentive in the case. D, except as law may otherwise expressly permit, a lawyer currently serving as a public officer or employee is subject to rules 1.7 and 1.9. And so now we're talking about not the lawyer who has left government service, but the lawyer who's gone from private litigation to being a government lawyer. And they shall not participate in a matter which the lawyer participated personally substantially while in private practice or non-governmental employment, unless the appropriate government agency gives informed consent confirmed in writing. Notice there's something striking here. You don't have to get consent in theory from your previous client, but you do from the government agency. And but also note that 1.7 applies, and so this could be directed versus parties that are directly adverse, or you have a material limitation on the matter, right? So if you're a government lawyer, you shouldn't be participating in a case against one of your own close relatives or family members, or a business that you own a share in or something like that. Classic conflict of interest. D continues, except as all may otherwise permit. You also shall not negotiate for private employment with any person who is involved as a party or as a lawyer for a party in a matter in which the lawyer participating personally and substantially, except that a lawyer serving as a law clerk to a judge, other adjudicative officer, or arbitrator may negotiate for private employment as permitted by 1.12b. So we're going to have a special rule for judicial clerks, and just kind of spoiler here, or preview, that's because people tend to do judicial clerkships for a year or 2 years, 2-year terms, and then they cycle out and go to the private sector. Very, very common. And so we have a special rule for that. What we're worried about here is you're a lawyer with the Department of Justice, let's say, in their civil division, and you're thinking of making a career change, and so you start talking to a party against whom you're bringing an enforcement action, let's say a regulatory enforcement action, and you happen to mention to their lawyer or to the company, hey, are you guys hiring in your in-house legal department or something like that? We really don't like to see government employees, when they're either bringing an enforcement action, or it could be that you're a government employee who's overseeing outsourcing, contracting. The government agencies hire contractors or private companies to do tasks for them. And so we don't like to see them using their government position and parlaying that into a private sector position. Now, if you leave your government position and then apply for private sector jobs, of course it's going to be that government work experience that you have brings a salary premium. And so, by the way, for my law students, if you have a chance to get a government legal position, all things being equal, I would encourage you usually to jump at the chance, right? It's most of the positions allow you to have reasonable hours and work conditions. It pays enough to live, but not enough to get rich. But the real reason to do it is you get experience that the private sector really values highly. And so a lot of former government lawyers can command a higher salary in the private sector because of that. But what you can't do is, while you're a government lawyer, use your leverage to get a private sector job with somebody who's on the other side of a case that you're working on. If it's not a case you're working on, that's fine. But if it's a case you're working on, you can't, it's off limits. E, as used in this rule, the term matter includes any judicial proceeding, application, request for a ruling or determination, contract claim, controversy, investigation, charge, accusation, basically anything that government lawyers work on practically, except for when you're doing legal analysis of proposed legislation, I suppose. Or one time when I was working as an assistant attorney general, sometimes they would have me review pending regulations or draft regulations that they were thinking about promulgating at one of the state agencies, to write about the legality of it and the legal implications and if the wording is just right and so forth. But otherwise, anything that's a matter with another party, almost anything, even if it's still at the investigatory stage, is going to trigger 1.11. 2, any other matter covered by the conflict of interest rules of the appropriate government agency. Now, I'm trying something different in this video with the review question. This is an actual test question or quiz question. And what I'm going to do is, just a quick flash, I have the answer and the explanation on the next slide. So what I would encourage you to do, if this is the first time through the video, that you pause your video, read the question, see if you know the answer, and then go to the next slide and read the explanation. And if you are completely confused, you probably should review the video.